Morning, everybody. Today is Thursday, July 24th, 2025. We're here for a town board work session, and if we could all please rise for the Pledge of Allegiance. Councilwoman Waski, would you mind leading us?
Yes, Supervisor. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Councilwoman Waski. Okay, first item we have on the open session today is with Rich Zuckerman, Esquire, and it's matters surrounding a CSEA grievance hearing, and it will be with Council Howard.
With the Zuckermans.
Okay? We defer to Council Zuckerman?
Well, thank you. Good
Councilor
morning, everybody.
Good morning.
So we're here today because the CSEA filed an appeal of the denial of some grievances. There's one that's in front of the board today. I'm sure that the town attorney has walked you through this. If I say anything now that is inconsistent with what he told you, whatever he said goes. Because it's an appeal, the CSEA goes first. They will present to all of you their arguments and information about why they think that their grievance should be sustained by the board. We will provide you with information as to why we think you should sustain the denial of the grievance, in other words, reject the grievance. Historically, there have only been a handful of town board grievance hearings. They've usually been waived. I think the last one that I participated in probably goes back to the 90s. I think that is the last one. And the way that worked, for whatever it's worth today, is the parties made their presentations. The board just listened. There was no interaction. There was no cross-examination or anything like that. It was very informal. And then the board took everything under advisement, which is a lawyer way of saying, we'll think about it. And then sometime between now and I think 20 days from now, you all consider the grievance with the town attorney as your advisor. And then he will work with you to prepare a decision as to whether you're going to sustain the grievance or deny it. That gets issued to the parties. If the union likes it, that's the end of it. If the union doesn't like it, they have the right but not obligation to go to arbitration.
Can I just ask a protocol question? Because often when we talk about union contracts issues and so forth, it's executive session. So can you just clarify for the public why we're specifically doing this, in open session?
Councilman, I don't know, I don't have an answer as to why we're doing it in public as opposed to executive. My opinion was not sought about that. But what I will tell you is that it can be in public session. The contract does not require that it be in executive session. I suspect the town attorney might tell you that a grievance appeal is not one of the listed items that can be done in executive session. Okay. That's probably why it's in public session. But I defer to him again, with regard to his opinion.
No, that is accurate. In my assessment, it didn't qualify as one of the matters that can be referred to executive session.
Okay. That's all.
Okay. CSEA, are you ready?
I don't know if I have do I get the, do I have an option to object to that? I don't have any problem doing this, and so I'm going to begin. So our grievance is filed. Simply put, a grievance that I am Gretchen Penn, Labor Relations Specialist for the CSEA. I will be the spokesperson at this step of the grievance process. The following step, should or if we go there, is handled by CSEA counsel. So an attorney will do the binding arbitration step of this. So in my position, I look at the black and white language of a contract, and that is the simple definition of a grievance, was or if we believe it was violated. So in front of you, you have our filing of the flex time article. So that is, for the record, Article 3, Section 2, letter C. So when you look at that language that's in the contract, it reads, all full-time employee and his/her department head, upon their mutual consent as well as the approval of the town supervisor and CSEA president or their designees, may flex the employee's work hours within the employee's defined work week, provided that the impact upon the town is cost neutral. So the grievance is filed because on or about April and ongoing, the town issued a different, not the contractual process of applying for, being approved for, and having flex time, simply put. So thank you.
That's it?
Sure.
Okay, I didn't want to step on your toes.
No, that's good.
Okay.
Okay.
All right. Thank you. Council people, that summary of what is before you is not exactly the full, or maybe it's too full of a picture. So we're here today, like we've discussed, because there's been an appeal of 3 class action grievances, 2 of which have already been sustained by the town. So the only one that's before you today has to do with, in summary, how can and when can a flex agreement be terminated? Okay? So what you are charged with doing here is the appellate body is interpreting the contract as it is written. Even if maybe we want it to say something else in the future, that's a negotiable item we can discuss at another point. But for now, we're looking at the contract language itself and trying to see whether, on its face, it's been violated by what the town has or has not done. Here, as Ms. Penn mentioned, we're looking at Article 3, Section 2C, which is flex time, and that provision talks only about how or why we can enter into a flex agreement. It does not address termination. What does address termination, however, is the flex agreement itself. That document was appended to the union's grievances, and when you take a look at it, and I have copies here for you if you want to look at it, but if not, I will spare you the extra papers. But when you take a look at it, it shows you that among other ways that this can be terminated, notwithstanding the above, a department head or employee shall have a mutual right to terminate the agreement upon 15 days written notice. Now, I'll emphasize that it's a mutual right. The department head or the employee, either one, can terminate this as long as we give 15 days written notice. No need for a reason, no need for a why, a who, a what, a when, other than the 15 days. And that is what happened here. Although, to be fair to the CSEA, when the initial denials were issued, the letter was off by a day. So those letters were rescinded, and new ones were issued in July 7th of this year, which did provide 15 days notice, which expired yesterday. Now, the scope of what we're dealing with here involves, as far as we are aware, 2 people, because there were originally 3 denials, one of which was rescinded entirely, and the other 2 were not, and those were the letters that were reissued. Without getting hyper-technical, from a procedural standpoint, the original grievance itself is moot. It's no longer applicable because when we rescinded those letters that were initially issued and did not terminate the flex agreements, there was no more grievance there. That the letters were reissued in July should have triggered, but did not, within the time frame provided in the contract, another grievance, and we don't have one. So respectfully, I think it should be denied on the basis of it being moot in the first place. But even if it was not moot, it is not a violation of the contract language, which only addresses how do we enter into a flex agreement. And I'll stop there.
Comments?
I am going to not respond, not because I agree or disagree, but I do disagree. I will leave it up to our attorneys at the next step, should we end up there.
Okay.
Thank you.
Both sides are completed?
Yes, sir.
Okay. I would say the hearing is now over.
Very good. Good day.
Thank you very much for coming in. Appreciate it. We will reserve our opinion at this point in time, and we will discuss, and we will come up with a decision within the next 20 days.
Thank you.
Thank you.
Take care. Good to see you all.
You too. Okay, next item we have on open session is matters surrounding a change in fines for Chapter 301-303 G2, no site plan, and that will be with Counselor PILO.
Good morning.
Good morning.
Okay, so all of these I did discuss in passing on the last work session, so we're here today just to talk about the specifics of what fines they are and what we want to move them up to. Does everyone have a copy? I have plenty of copies if not.
I don't have a copy of the code, and I have this, I have that, but I don't, I
So
mean,
these are the applicable sections of the code you have with the changes?
We have 301,
Just
dash
fine.
320
penalties?
penalties for offenses.
Yeah.
Yeah, okay,
389,
Okay.
289,
no site plan.
Right, okay.
231.
So we'll go from there. So, 301 has not been updated since 1989. So it's a little bit older than me. So, based on the rate of inflation, based on what we're seeing for the 301 level offenses, it's mostly site plan, but also another important subsection under 301 is it addresses illegal rentals. When it goes from one family to two or more families, they usually, in conjunction with the no rental permit, they'll get hit with the 301 charge. So we want to see that move up so that it'll be a nice supplement to the fines that we're already collecting on no rental permit. So for example, if someone got a $3,000 fine for a no rental permit, then we could supplement with this with another 1,000 or so. So right now, the fine schedule under 301 since 1989 is $0 minimum and $1,000 maximum. So what I'd like to see, and also get your feedback from if I should go a little bit higher, but also keeping in the understanding that we want to have some sort of range for those who, do the right thing, and by the time they get there for arraignment, they have all their permits in. So right now I was looking at setting the minimum fine to 500 and the maximum to 5,000. So if anyone wants
Can
to,
you just explain, in terms of no site plan, is this for, commercial establishments, a building in
Yeah, so
something
it's
in which is
mostly-
already operating and just never submitted anything, or just clarify what?
yeah, so if they could be operating already and not doing that, that would be where we would go more toward the $5,000 range, because that's, it's kind of balancing the intent of the defendant.
Could
they-
somebody have a building, like a CO for a property, but still no site plan, or you would never get a CO unless you had a site plan?
I would hope that there would be no CO issued if there was no site plan, but,
Okay. So it's just somebody moving into a building,
Yeah.
basically refurbishing it,
Right.
setting up shop and opening up, right?
yeah. So then we could,
Clarify exactly what we're talking about in terms of the fine of what they've done,
Yeah.
before we establish the fine.
so they would be charged under 301, and they would also have the no building permit, no CO. So those can all supplement each other and come back with a more robust fine, because it's multiple charges. So those usually go hand in hand.
Okay. Thank you. Just,
For me, since it hasn't been changed since 1989, and, and I understand the adjustment on inflation
Right.
as it pertains to the fine, but then I also look at the labor involved, and I would like to see that minimum at 1,000.
Okay, we can do that.
I
mean,
agree.
All right. So
I'll agree to that.
we'll do 1 to 5 so that there's, wiggle room for, based on how many adjournments we have and how quickly they do put their applications in.
I think the minimum of 1,000 is good just because of the safety aspect. So if you tell me that you don't have a site plan, that means that you've never had a fire marshal or
Right.
anybody else walk your premises.
Right. So I agree with that. All right, so we can, I don't know what the next one is, but we can move on to that.
Next is matters surrounding change in fines for Chapter 289-29 Wayland.
Okay. So this one has not been amended since 2001, so a little bit better, but still coming up on a 25-year anniversary. So these, you know, we know the costs that go into repairing the roads when overweight trucks are, you know, wearing and tearing on them. We know the cost of enforcement when these, you know, putting signage up, having PD go out, all of those things. So right now it's up, again, the floor is at 0 here. It's 0 to 100 for the first offense, 0 to 250 for second, and 0 to 500 for third. So it's pretty apparent that those need to be refreshed. So just as a starting point, you know, I kind of just doubled all of them. Well, no, I didn't.
5 times.
More than
5
double.
times.
Hey, you more, yeah, which is,
I did. So I don't know if that's something that we want to keep as how I put them, or if we have any input on.
I'm going to advocate for the first one to be 1,000,
Okay.
the second one to be 2,000, and the third one to be 3,000, and only because we know the cost of, you know, when we have to put asphalt down.
Right.
And what's involved, and we need to get up to speed with, you know, with the, what the real costs are.
Okay.
This also helps with the situation on Youngs Avenue with the trucks, you know, going the
Absolutely.
wrong way
Yeah.
up there and driving
Yeah.
on the
Yeah. because-
local roads where they don't belong.
And I totally agree. It has to be enough. It can't be a cost of doing business.
Right.
You know, I mean, it has to be a cost to the business. Otherwise, it doesn't work.
Yeah.
It's not really saying the first fine is $1,000, it's up to $1,000.
Correct.
So the judge is leaving room for a judge's discretion.
Right.
Well, yes.
Yeah, but how do we, okay, so a judge could determine that it's 0.
Sure.
And,
Can we
or-
have a not less than?
Can we
Yeah,
do not,
we could do a range instead.
can we do not
Yeah.
less than 1,000? You know, just
Well-
give in the
Well-
I would
severity.
do not less than
500
500.
to 1,000.
500 to
Yeah.
1,000.
Okay, I'm good with that.
I mean, I see in the fall during our pumpkin season on Peconic Bay Boulevard, you have your party buses that are, you know, using the boulevard to deter the traffic on Main Street, and Peconic Bay Boulevard was not built for that kind of traffic to be on the road.
No,
So,
there's too many small bridges with culverts underneath them that weren't built to withstand that kind of weight.
yeah.
Counsel, I'd ask that to be applied to all 3
Right.
steps, you know, so even on the second offense, that then on the second offense, it
1,000
should
to
be,
1,000 to 2,000?
yeah.
And then 2,000 a
So
fourth.
each offense should be the maximum, starting at the maximum of the previous offense.
Okay, got it.
I do have a silly question, though. What happens, like, if you have a furniture delivery truck that's coming into the
That the
area?
exception in the code and V&T laws for local deliveries.
Okay,
Yeah, so they would have to show their proof of,
Their bill
Their
of
delivery to
landing.
yeah,
landing.
exactly.
okay.
Yeah.
Where they're going.
Right, last but certainly not least, we want to move on to 231.
Okay, next item up is matters surrounding change in fines for Chapter 231-66, the fire marshal.
Now, we have very recently refreshed this, but not the fines. We just, what was it, about a month and a half ago, we did that exception to make one of the misdemeanors a violation so that the fire marshals would get more credit on the dispositions. So technically, this section has been refreshed this year, but not for the fines. They have a pretty good fine schedule right now, 250 to 2,500. But as I mentioned last week in the last work session, I think, you know, I believe everyone in this town would think that the fire marshal, offenses are, you know, we gotta balance that, the dangerousness factor and the risk, you know, storage of fireworks, for example, things like that. You know, although individuals could be charged criminally, it's important to have a deterrent, on the town side as well. So, I was just gonna, double it for 500 to 5,000. Based on our last few minutes of conversation, I'm gonna imagine that we wanna do 1,000 to 5,000.
Can you just clarify, because it says shall be guilty of a misdemeanor, I thought on some of the fire marshals, things that I just want to, because I don't see the prior code to what it's referring to, I thought on some of the fire codes that some of them were not in fact a misdemeanor and were like fines would be directly to landlord or homeowner.
So we only have one that's not gonna be a misdemeanor anymore. That was I believe it was 23155. Are you talking about civil penalties or?
Yeah, just, it says that, I just don't see when it says any person shall violate the provisions of this chapter, so I thought there were certain provisions within the chapter that were not in fact misdemeanors.
So that's, I believe we put that in section D. Shall be guilty of a violation level offense. That's where we added the section D.
Okay.
It's still punishable by imprisonment, all of that stuff, but that's what we added recently.
Okay.
Anyone that violates 231.8 or 231.25 will get the benefit of the violation level as opposed to the misdemeanor.
Council PILO, can I just ask you a question?
Sure.
With regard to the CPL or the penal law, are there requirements statutorily as to what a maximum and a minimum can be? Are we within those?
So, you mean for the justice court?
Yeah.
I have yet to find an exact amount. So the most I've seen in our code or in other codes are, I believe, 8,000, possibly 10,000.
Yeah, Southampton has one that's 10,000.
Yeah, so, but I cannot find anything written of what the ceiling really is, but I'll
Okay.
keep looking.
Or the minimum, like what you absolutely cannot charge?
Right.
Below
Yeah.
or above? I was just curious if
Yeah.
there's anything. Okay.
Victoria, can you give some more context? I mean, you mentioned fireworks. One of the things, give me some context on something that would take more than one trip to a location, or they'd be on location for X amount of time. Because I don't have the code, you know,
So you just want an example of a situation?
yeah, because yeah, that would help to understand these fines, especially the lower one, if that's enough.
So the lower one, I mean, anything under 231, you know, a lower one would be a no place of assembly permit. That requires pretty minimal
Okay.
staff involvement. That's really, you know, putting in for the permit, having the fire marshals
Right.
maybe go out there once, and it's the simplest of.
Okay, what about 231-8 or 231 oh, we already did 25.
Yeah, those are violations.
Yeah, that's
Yeah.
the no place of assembly, and that's the, I can't think of what the other one is. But a lot of, I mean, a fraction of these are, you know, just getting their permits in and having the fire marshals,
Okay.
you know,
Yeah,
make
that-
one visit and accept it. And a lot of them, as I think I mentioned in other meetings, you know, most people, they might not get their mail, and by the time they get their mail, they quickly apply for the permit, and by the time they're at arraignment, it's already done, and the fire marshals will contact me and be like, you're good to go on this, you know, they
Okay.
did the right thing, they just, you know, something was going on in their life or something.
So if they're a repeat offender, does that,
Well, that's where I would go closer to the $5,000 range. It would be kind of discretion
Right.
between myself and what the judge would agree to for the sentence.
okay.
But yeah, I would like to keep it, the lower end of these, you know, to match the violation level.
These look fine. I mean, for me, they look fine.
Okay.
No pun intended.
So that's what I have. I know myself and Councilman Kern are gonna, you know, kind of do these in three at a time waves and try and see if we can pick out and find more that haven't been refreshed in a while. And we'll try and figure out a way to be able to locate these more efficiently so that we can look at them at the end of each year and make sure that,
Inflation.
yeah.
Yeah, thank you for the work.
Very good. Yes, thank you very much.
Thank you.
Just
Much
think-
needed.
I think also, though, that when you're increasing fines, I always think that, like, everything that we do in town hall needs to become more closer to self-sustaining, and just the sheer cost of us eventually, we are currently working on a plan to rebuild the court system, but, just the idea of employing judges, attorneys, court officers, everyone within our legal department, like, there's a cost of operation. So it's
Yeah.
not just that we want to sit up here and want to be mean to people or take money, but
These
yet
are people that
it's the
aren't
best that you
utilizing-
can to
yeah.
cover your costs to facilitate the entire process. And the fire marshals covering a portion of their costs to go out to a site 2, 3 times or whatever to make sure that somebody's in
And
compliance.
I think that's a good point, and that's a good thing to take from this, is that these are fines, not fees. So fines
Right.
are for people that violate the town code.
Yeah,
You know,
and-
This isn't affecting the taxpayer, this is for the people.
And 9 times out of 10, they know they're violating.
Yeah, so this is,
And it's meant to be a deterrent as well. Don't do
Right.
it.
And to piggyback on what the councilman is saying is that there's no reason why taxpayers who are not violating any of these codes are subsidizing the ones that are with low fines.
I agree. Yeah,
Well, especially where the rentals are concerned, because the landlords are making so much money, and that little slap on the wrist does nothing.
yeah.
So we'll see you back here in 30 years when we approach the fines again.
No, we're working at, we think we have a system we're going to pass by Eric that may identify all the fines at once, so it's an easy search.
I think it should be a booklet every January that we just
Yeah.
simply
That's what
cost of
we're
living
working
on.
increase
That's a
and to
lot.
continue on.
Yeah, we're doing that with every department, including legal.
Yep, so,
Great.
excellent.
Okay.
That's good, thank you very much.
Thank you.
Thank you, Councilman.
Thanks, Victoria, really appreciate it.
All right, I have a couple announcements before we finish up here. And first announcement is Saturday, July 26th, beginning at the Peconic River, is the annual paddle battle hosted by Long Island Aquarium and New York Marine Rescue Center. The races begin at 9:15 a.m., and that is along Heidi Bear Way back behind town, right on the river. Second item, Saturday night, we have another scheduled live music at Wading River Beach. I know the Wading River people have been waiting for this, and if it's even a small amount as successful as the Jamesport one was, which I'm sure it's going to be every bit as, it will be a home run. And I'm so glad that you put this together.
Actually, Councilwoman Merrifield.
Yeah, and the
She's
people,
It was your committee, and you guys definitely had you started the whole.
Well, we started it, but
Absolutely.
now you're expanding it,
Yes.
and I think that's
I'm
wonderful.
very excited about it.
and just to note, there's no alcohol at
That's right.
these. For some reason, people are misguided and they get information from people who don't know what they're talking about when they put it up on their website, and I won't name the person, but, if you're running for office, get your facts straight before you put something up, that's all I'm going to say.
Right, there's no alcohol at the
Right.
beach. And you do need a Riverhead parking permit, beach
Correct.
permit to park there.
Yep.
Recreational park.
It's for our residents.
Absolutely. And the third item is tomorrow, Friday, July 25th, it's expected to see temperatures in the 90s and maybe feel like 100. So once again, the Riverhead Senior Center will be open as a cooling center from 8 a.m. to 4 p.m. So if you're in an area or you don't have air conditioning or fans and you want to get some relief, go on down to the Senior Center. It will be open from 8 a.m. to 4 p.m. And that's all I have right now on announcements. We are going to now close open session and go into executive session to discuss under legal matters surrounding possible sale of real property. That will be with KERN, HURLEY, and Thomas. So if I could, can I have a motion to close open session and go into executive session?
So moved.
Seconded.
All in favor?
Aye.
All opposed? Okay, open session is closed. We will go into executive session, and everybody, thanks for tuning in and have a wonderful weekend.